shall kindly introduce.
Good morning, everyone. Now I'll be introducing today's speaker, Advocate Juhi ma'am. Advocate Juhi is a lawyer by profession. She has vast experience of more than 7 years in crime against women and children, public interest litigation, corporate litigation, civil litigation, contract management, IPR, and in many more fields. She is trustee of foundation leading the project. She has delved deeper into creating awareness and educating people about prevention of sexual harassment of women at workplace as well as empowering women and men with regard to their workplace rights and responsibilities towards opposite gender. She has taken more than 75 training sessions across all sectors of society, and she has trained more than 100 people, building their capacity in educating others about POSH and empowering them towards the betterment of society. She is known for her excellent communication skills, which encompasses public speaking. She is a regular speaker on various capacity building, self awareness, legal topics at various multinational companies, professional institutes, law colleges, and other institutions. She is member of various committees across big corporate houses, including Internal Complaint Committee formed under Prevention of Sexual Harassment Laws for Women. We welcome you, ma'am.
Good morning, everyone. Today's topic we are having is the time. It's a very, very important topic which we all should know individually as well as being employer. We should know about this law. We should know about this compliances and the recent developments in this law. So we will discuss today the entire scenario, why this law was needed, what was the need first felt, which led to came into this force. And the second thing, what are the compliances under this law? After that, we will discuss the recent developments, the recent judgments of the Supreme Court and the high courts of various states, in which we will discuss what are the problems being faced by the society and the organizations these days, and what is the ruling in that. So we'll start with the PPT, where we can discuss the things in the elaborated form. The slides are visible to all.
Yeah.
Oh. This is sexual harassment of women at workplace. Now we'll discuss this law is particularly for a woman, but there is no prohibition if we comply these provisions for a man also at the workplaces. And we will discuss the organized sector, unorganized sector. If anybody is employing a domestic help, the gardener, drivers, every employee having been there in their houses, in their offices, they all are covered under this law. So they all have to comply this law. We will discuss the two scenarios where local committee comes into picture, where the internal complaint committee comes into the picture. There are three laws which is governing the sexual harassment. The Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, and there are certain rules also made thereunder. So these are governing the full-fledged law for prohibiting the sexual harassment, preventing it at the workplaces. Indian Penal Code, there are different sections of Indian Penal Code which was already there prior to this act, which came into force in 2013. Industrial Employment Standing Orders Act, which sanctions certain provisions that these activities have not to be committed at the workplaces, otherwise it will comes into the sexual harassment purview. So these are three laws already governing the sexual harassment at the work. Now this is very important for all of us to understand why the need is felt. Why the need is felt to have this law. We are having many participants here. Anybody heard about this Bhavri Devi case prior to this? We will have this one-to-one so that there are responses also, so that we all will be involved in the discussion type of session. So anybody prior to this heard about this?
Great to hear from you, Juhi. All the best.
Okay, thank you. So most of the time we will think that there is always a problem. That is why the legislature feels the need that why the law should be made on this and why the law should come into force on this particular issue to resolve this. So this is the case where the first time need was felt that there should be a law to prohibit sexual harassment at the workplace. And this has happened in 1992. There was an incident with a social worker whose name was Bhavri Devi. She was working for the campaign of state of Rajasthan, and for basically she is working for preventing the child marriages in the state of Rajasthan. It was prevailing prior to this, not even only in Rajasthan. Apart from that, in many states, in many villages, there are incidents of child marriages. So she is mainly involved in prohibiting the child marriages. And what happened? There was a Gujjar family. They were getting their, I think, 9 months old baby to some man. So she reached there with the police officials, district collector, and other officials, and she stopped that marriage. Out of anger, the 5 mans of that Gujjar family committed rape on a Bhavri Devi in the fields of Rajasthan when she was working in her fields with her husband. In front of her husband, they all raped her, and they brutally beaten up her husband also. But due to medical examination not done on a time, FIR was not registered properly, because they all people are the who were accused, they are influential people in that particular state or the village. So FIR was not registered on time, medical was not properly done. Due to all these reasons, lack of evidences was there. So due to lack of evidences, they all get acquittal from the court. After that, what happened? There was a anger amongst the people after this case, that all the NGOs who were particularly working for the rights of a woman, they taken a recourse, and with the other lawyers, they have done the with the other lawyers, they have filed a PI in the Supreme Court for the first time. And the NGO named Vishakha, with the lawyers and women activists, filed this PIL. That is why the guidelines framed under this PIL are named as Vishakha guidelines. So the Supreme Court in 1997 felt the need, after this PIL, first time felt the need that there should be law to protect the women at the workplaces. If she is subjecting to any kind of sexual harassment at the workplaces, she is not having the equal rights like a man, because mans are properly, they are free from all such stress that they will face any such kind of sexual harassment, and they are working, they are focusing on their work. But if the woman is going through all such things, she could not focus on the work properly, and she is always having the back of mind that she can at any time subject to such incident again. So that phobia, that kind of threat she is having, will not allow her to properly work and to give her the equal right as a man. So that is why in 1997 Supreme Court first time framed the guidelines to be followed at the workplaces for sexual harassment. And apart from that, also requested the Union of India to legislature to frame the proper law on this particular subject. So after that only the enactment has came into force. And Sexual Harassment of Women at Workplace Prevention, Prohibition, Redressal Act 2013 came into force. The legislature, after this guidelines and after requesting by the Supreme Court, they all felt the need that this law should be framed. And all the guidelines which were framed by the Supreme Court, most of the things are taken from these guidelines also, and elaborated provisions are also made regarding the prohibition of sexual harassment. So this is basically the need why we had this law. Now we'll discuss the name of this act is itself deciding, itself predicting that what is the preamble of this act. The Sexual Harassment of the Women at Workplace Prevention, Prohibition and Redressal Act 2013. It provides some preventive measures, that what measures we should take prior to any incident of sexual harassment happens with anyone. what prohibitive measures we should take. We should timely have the webinars, we should timely have the sessions, we should have the work uh, some time of signs at the workplaces. We should display at our notice board the names of ICC members. Whatever we can do to prohibit the sexual harassment at the workplace, these also comes into this act. And redressal. Apart from taking the preventive measures and prohibitive measures, if there are any kind of sexual harassment incidents or any kind of such behavior done at the workplace with any women, then there are some redressal measures also, that how to file a complaint, how we can redress that, how the during the inquiry, how the women should be handled. All such things should be mentioned in this law, and this act is properly known as, also known as POSH Act in the short. Mostly people call it a POSH Act. Now we'll discuss the need, why the need was there for having this law. We have discussed that. Now the important thing is sexual harassment. What is the entire act is revolving around this definition only, that what is sexual harassment. Now we'll discuss any unwelcome act or behavior, either directly or by implications, physical contacts and advances, requests for sexual favors, making sexually colored remarks, showing pornography, and other verbal and physical conduct of a sexual nature. It includes everything in it. The definition is of 4 lines, but it includes everything, whether it is direct or by implication. You are not directly saying anything to a woman, but you are by implication, by your gestures showing something like that. Then it is a unwelcome act, and she is not welcoming it. She is not participating in it. Then you should understand that you should stop there. Physical contacts and advances. Any kind of physical contact which is unwelcome by a woman, that is also a sexual harassment. Request for sexual favor. If you are for any kind of appraisal, any kind of promotion, or any kind of work or project giving, you are asking sexual favors, being a senior, then that is also a sexual harassment. Making sexually colored remarks, like somebody is having a lipstick or a dress, you are making a sexually colored remarks on her appearances, then that is also sexual harassment. Showing pornography, you are opening something in your laptop at the workplace or in a phone where the woman is also standing, and it's a office area, and she sees us things and gets uncomfortable, then that is also sexual harassment. And other verbal or physical conduct of a sexual nature. Any kind of it could be a verbal or a physical conduct or your gesture. That all can be sexual harassment if it is unwelcome by a woman. It is any conduct that is sexual in nature and unwelcomed, imposed, and unreciprocated by the recipient. This is very important to understand, unreciprocated by the recipient. If the woman is not actually involved in it and she is saying you to stop, or she is showing her by her behavior that she is not liking it, then you should stop there, whosoever is doing that. Now we'll discuss certain expressions which can be at the workplaces. People casually think that this is a normal kind of behavior, this is a joke, we are not normally enjoying. This is not like that. We have to be very careful now that any kind of incident which is normally a joke or a casual behavior for you can hurt the sentiments of others. So asking someone out on a date, this kind of thing, like you are again and asking your colleague or someone working with you who is a woman. Now she firmly said no, despite that you are again and again asking the same thing, that is a sexual harassment. Staring or watching someone which is making her feel uncomfortable, that is also a sexual harassment. Complimenting someone on their appearances. Complimenting to the extent she's liking it is okay. But if you are making any sexually colored remark kind of a thing, like on her appearance, on her lipstick, on her dress, anything like that, which is which hurts her, so that is also a sexual harassment. Having an affair with a colleague. Having an affair, most of the time people work together, they get into a relationship, but now what happens if the relationship gets sore at the end and there is a worse thing between the people? They can use those things like messages, whatever, calls, recordings, other things, which can be used as a weapon. So we have to be very careful. Unnecessary sending flowers or gifts. If you are sending flowers or gifts unnecessarily in front of other people, she is getting embarrassed by that, then that is also a sexual harassment. Imposed unreciprocated behavior, we have discussed that. Any kind of imposed behavior which she is not liking, that is sexual harassment. Leaving notes for someone, if you are giving any notes or sending in a file or keeping on her desk and somebody has read that, that is can be a embarrassing thing for her, that is also a sexual harassment. Flirting unnecessarily, if she is not involved in it, she is not reciprocating it, you are flirting with the woman again and again, that is also a sexual harassment. Now we'll discuss certain incidents of sexual harassment like obscene gestures, sexual teasing, suggestive looks and remarks. Like we have discussed, it is not always verbal, it is not always direct. It can be gestures, suggestive looks, or making a remark. That can also be a sexual harassment. Sexual or unfriendly remarks, gender-based insults or taunting, like gender-based insults or taunting, it can be most of the time the man says at the workplaces that this is not a work of a woman. You cannot do this project, you cannot do that work, you are a woman. Such kind of remark can hurt the sentiments of women. So you should abstain from doing that. Sexually explicit telephonic calls or emails. When we were working from home during the corona period, or somebody like in IT sector, most of the people still working from home and all such things, then in that case, telephonic calls, if you are making, which is bothering a woman, or emails, through emails, you are sending something obscene or such kind of a thing, you are bothering a woman, then that can also comes under the purview of their sexual harassment. Display of pornography, we have already discussed. Any kind of physical deliberate contact, like you are intentionally touching or leaning over or cornering her or hindering her way, all such things, you are coming into her way intentionally, all such things are sexual harassment incidents. Now we'll discuss, if any woman faces sexual harassment, then what is the impact on her? What is the impact of sexual harassment on a woman? Sexual harassment at workplace is considered as a violation of women's rights. We have discussed that every woman is also having the same right as a man's. If they are having the right to work freely, free from any stress, then that woman is also having a right to work freely and with her right of equality. She should be given all equal opportunities, all equal behaviors, and all equal gestures like a man. And with the life and liberty, all rights are available with the women also. So if she faces any kind of sexual harassment, all these rights get affected. It creates an insecure and hostile work environment, which discourages women's participation in work, thereby adversely affecting their social and economic empowerment and the goal of inclusive growth. If the organization is hiring any woman, if we being an employer or we being an employees getting employed in any organization, definitely the organization expects something from us. And that expectation, the goal of inclusive growth they are having with us. So if we are not being provided that environment, we are facing any such kind of behavior there, then work environment becomes hostile for us. Then in that case, we will not be able to give 100% efficiency, and the proper work and productive work we cannot provide. So in that case, there will be a harm to the goal of inclusive growth of the organization also. So that can be, if that can affect the goal of inclusive growth as well as the health of a woman, her mental health, physical health, as well as financially also. So all these impacts are there on a woman if she faces any kind of sexual harassment. Now we'll discuss, and what is the impact? Women, we have understood what is the impact on a organization. There is a brand value of any organization, whether it is a small or a big. If there is a proprietorship also, there is a value of the proprietor. He has created some image in the market, or whatever the organization is having, there is a brand value. So if any woman subject to any sexual harassment at that workplace and she goes outside and tells about that to anybody, that I have faced this at that place, then definitely the people will have negative thinking about our organization. So it's a negative publicity about our organization. Decrease morale and decrease efficiency of employees. definitely the woman's morale will decrease and she will not be able to trust any team member. And she is always being in the fear that she can subject to such incident again at any time. So decreased efficiency will be there. Loss of money for non-compliance of provision of law. If we fail to prohibit any kind of sexual harassment at the workplace and any incident happens, then there is definitely a loss of money in terms of fine, penalties for non-compliances and for litigation also. If we have to conduct a ICC meeting for resolving the complaint and all such things, it all takes the resources. Now I'll discuss the definitions, which is very important under this act. Now, if we will understand that who is the employee and what is the workplace, then only we can come to know about our rights, that what is the right we are having, whether we are fall into the definition of employee or not, whether we can file a complaint or not. So this is very important for us to understand. Now, most of the law covers the only regular employees, but this law covers the regular employee, temporary employee, ad hoc, daily wages employee. All the employees are covered under this particular law. Any woman who is whether coming for the ad hoc basis, daily wages basis, and working for us, she is covered under the definition of the employee at workplace, either directly or through an agent. Whether we have directly by interview hired her or him, or whether we have appointed some agent who has hired her with or without the knowledge of the principal employer. So that employees are also covered under the definition of employee, whether or remuneration or not, if we are paying or not paying, because there are social causes also most of the time where the people voluntarily come for working with us, so that can also be a employee. Whether the terms of employment are express or implied, whether we have given an offer letter, appointment letter or not, if they are working at our workplace within our premises and for us outside also, visiting clients for us, then they all are covered under the definition of employees. Employed by contractor, co-worker or a contract worker. Even the trainees also at the workplaces includes in the definition of employees here. So this is a very vast definition under this act. Now we'll see what is workplace. These two definitions are very, very important, which we need to know whether we are covered under this or not. All the premises includes the corporate office, head office, branch office, and all other premises, location, establishment, institution, units, and sites controlled directly or indirectly by the company or where the business of the company is conducted. So any place from where the business of the company is conducted, whether it's a field work, site, or branch office, head office, or any kind of office from where the company conducts its business, they all covered under the definition of workplace. At the time of COVID, when we were working from home, that is not the branch office, work office, or whatever place, but we are working virtually from home. So that is also from wherever we are working, that places are covered under the workplace. And all other premises where employees of the company visit arising out of or during the course of their employment, including official events. Most of the time here we are CAs in this session. So when we are employing our trainees, our employees, they are most of the time for audit purpose and other things, they are visiting the clients. So that places are also workplaces, because during the course of their business, during the course of their work, they are going there. So this is our responsibility to provide them safe working environment. Includes the transportation and accommodation. If we are providing any transportation accommodation to our employees for leaving, then all such places are covered under the definition of workplace. If any incident happens in the transportation with the women, that is also covered under the definition of workplace, and we have to take the responsibility of that. Now we'll discuss prevention. What is the aim of this act? The aim of this act is no woman employee shall be subjected to sexual harassment at workplace. So prohibition of sexual harassment is the aim of this act, due to which this came into force. And section 3 specifically says about this. Now we'll discuss what to do. If we face any kind of sexual harassment, if any woman face any kind of sexual harassment, what should she do? she should not ignore it in the hope that it will go away. Prior to this act, what happens? There was if any incident of sexual harassment against any woman, when it is most severe, then what was the procedure? She had to go to the police station. She had to lodge a FIR, file a complaint. Then the police file. Then the police comes into picture. They investigate it and the entire court procedure, which was very lengthy and very harassing for a woman. That is why she was not raising her voice. And due to embarrassment, other factors in the society, she was never ever raising any her voice. But now this act is a full-fledged act. Why it is made? So that in a efficient and a smooth manner, her complaints can be entertained. Please mute your mic. Advocate Krishna, please mute your mic. Yes. So don't ignore it in the hope that it will go away. We should not think that it will go away on its own, because anybody who is harassing you, they can do this with other women also. So why not stop it at this moment only by speaking out? So we should speak out. Speaking out about sexual harassment is an effective tool in combating it. If we'll not speak out about it, if we'll not file complaint about him, then he'll keep doing that. So we should understand this and we should not blame ourselves. And we should always be confident in saying no clearly and firmly. If we don't like it, if we don't like any behavior, then we should simply say no clearly and firmly. Don't blame yourself and don't delay. We should not feel like victim all the time, and we should take a bold step and file a complaint if we have any such kind of incident with us. This is for all women. Now we will discuss duties of the employer. If we being an employer employing any of the employees, and whether if we are working somewhere also, then in both the cases, what is the duty of our employer? We should understand, and being an employer also, we should understand what is our duty to, for our employees. Provide safe working environment and safety from persons coming into contact at the workplace. Display at conspicuous places at workplace penalties and consequences of sexual harassment. Order constituting the committee. Order constituting the committee will discuss in detail that what are the organization who should constitute ICC within its organization, and what are the organization who should not, and LC when comes into picture. We'll discuss that. Organize workshops and awareness programs at regular intervals. Like in the companies where we are external members, we are timely organizing the workshops for the employees, so that they'll come to know that what behavior they should not follow at the workplace, and they should be aware that what are their rights and responsibilities towards each other at regular intervals. It should be in every 2-3 months, so that it will be revised by them. Display on the notice board of the premises giving full details of the members of ICC. This is very important. At the conspicuous places when we are entering into the premises, there should be the display board, and where it should be displayed properly that who are the members of the ICC to whom any employee having complaints can file a complaint. Providing necessary facilities to the committee for dealing with the complaint and conducting an inquiry. So this is also a duty of employer, that if any complaint comes up, then they have to provide necessary facilities to the committee. Internal complaint committee formed under the organization. Assist in securing the attendance of witnesses and respondents before the committee. And if despite notice of the committee, if the employees are not coming for witnesses and respondents not appearing, then it is also a duty of the employer to assist in securing their attendance. So this is all the duty of the employer. Now we'll discuss role of ICC. ICC, we have discussed that this is the duty of the employer to have ICC, to pass an order constituting the ICC and provide assistance to the ICC. Now we'll discuss that what is the role. If the ICC is constituted properly in the organization, then what is the role of the ICC? First and foremost role is to entertain the complaints and to inquire into the complaints of sexual harassment. Second, to make recommendation to the board of directors. This is very important thing we all should know. The ICC is not having any power to punish anybody. if it comes into the inquiry report that anybody is guilty of the sexual harassment, then ICC is not having power to punish him or take any action. It can only recommend in the report, inquiry report, that these actions can be taken against that person who is guilty of sexual harassment. These are the recommended actions can be taken. And the employer, that is board of directors of the company, they will only take that action recommended by the ICC to file annual report as per the provisions of the act. As per the provisions of this act, we have to, at the end of every calendar year, we have to file an annual report. So this is also the duty of ICC to ensure filing of it on time. So these are all roles of the ICC. Now we'll discuss very important thing, because here we are not taking a session for the company. Most of the people here are company secretaries, advocates, and the other employees or the individuals. So this is very important for us to know both the aspects of the committees. So complaint committees there are two types of committee, ICC and the LCC. ICC is for the organized sector. Organized sector, we can say, is the companies which is properly formed in the organized way, where the more than 10 persons are employed. When more than 10 persons, more than 10 employees comes into the picture, then in that case, we need to internally form a committee, whether it is a CA firm, CS firm, lawyers, or the company, or any organization which is properly constituted and which there are more than 10 employees are employed. They have to form ICC. They have to comply all the provisions of this act, as we have discussed. Now, LCC. LCC, where suppose at our home, we are having the housekeeping staff, we are having the driver, or the chef, or the gardener, all people we are employing, like 4, 5, whatever, they are there. So they comes under the domestic health and all such things. They are all covered under the unorganized sector. For those persons, if they are having any sexual harassment complaint, they will go to the LCC. LCC is basically the area in the particular district, the district collector. He appoints any officer from his office and constitute few members of the as a committee from his office, or the persons who are dealing with the complaints of a sexual harassment. They are aware of the women related laws. They constitute the local complaint committee. So those persons who are from organized sectors like house help and other things we have discussed, they can file their complaint to the LCC. So therefore, these two kinds of committee are being framed as per this act. We have discussed that according to the Post Act, every organization with 10 or more than 10 employees should have compulsory constituted the ICC. Every organization, this is for organized sector. Now we'll discuss who should be there in the ICC. Women. Most of the the presiding officer of the ICC, internal complaints committee, in the organized sector, the presiding officer should be the most senior level employee, or who is a woman. It is very important to know she is a woman. The presiding officer should always be a woman. So members, there are 2 other members required, not less than 2 members from amongst employees, preferably committed to the cause of a woman, or who had experience in social work or have legal knowledge. So these 2 members should be dealing with the women related laws. They are having the experience of handling the cases related to women. So all such people, out of those people, we can choose 2 members to be a member of this committee. External member. 1 external member is required, and that external member should be from NGO or any association committed to the cause of a woman, or a person familiar with issues relating to a sexual harassment. So it should be from proper NGO or proper association which is committed to the cause of a woman. This is very important for all of us to know. If the ICC is not properly constituted, the inquiries done by the ICC, that can be questioned by the courts. And we will discuss the judgment on that if ICC is not properly constituted, if the external member is like we are having retainership, we are having advocates, we have specifically hired any person as an external member, or any relative of the director, Most of the time, the companies are doing that also. They hired that person as an external member. She is not from any NGO, or she's not having the knowledge of handling the women-related complaints or women-related issues of sexual harassment. Then the ICC is not properly constituted if we are hiring any such person as an external member. So ICC, constitution of ICC is defective in that case, and the court can quash that inquiry done by that ICC. So this is very important for us to know that ICC should be properly constituted. In ICC, the companies are having 5 members also, and more than 4 it can be there, but at least 4 members should be there, and who should have this qualification, which we have discussed. Not less than half of the IC members should be women. Half of the, like if there are 4, then at least 2 should be a woman. The terms of IC members shall not exceed 3 years. It should not be exceeding 3 years. We should keep changing that. A minimum of 3 members of IC, including the presiding officer, are to be present for conducting the inquiry. It is not like that the 2 members are present there out of 4 and we have conducted the inquiry. We have resolved we have started the proceedings of the complaint. We should not do that. At least 3 members should be present. So this is important for us to know about the constitution of ICC. Local complaints committee. We have discussed the district officer will constitute the local complaints committee in every district so as to enable women in the unorganized sector or small establishment to work in an environment free of sexual harassment. LCC will receive complaints from women working in an organization having less than 10 workers when the complaint is against the employer itself. This is very important to understand the second point, that if in any organized sector also, if there is a complaint against the director only, then if any woman employee below her, or whatever the ICC is there, the ICC consisting of the employees who is employed by the employer itself, then there can be a biased decision. Therefore, this provision has been made that if there is a complaint against the employer, then LCC will handle that complaint. It has to be filed with the LCC. Employer's complaint will not be handled by the internal ICC. Okay. From domestic workers, we have discussed our housemates and all unorganized sector people can file a complaint to the LCC. Now we'll discuss these points of 2 types of committees we have discussed. Now this is very important thing. We are moving towards a redressal part of the act. That who can file a complaint and what is the time limit for filing a complaint. First of all, the complaint, how to file a complaint. It has to be filed in a written way. It is not like that we simply come before the ICC and say that this is the complaint we are having and this person has committed a sexual harassment against me. This is not, oral complaints are not mentionable. It has to be written with 6 copies of the same along with the supporting documents, whatever supportive documents you are having, any email, any WhatsApp messages, any kind of recording, whatever the woman is having, she can file with her complaint and clearly specify the name of the person against whom the complaint is being filed. The name of the person who is being accused in this complaint has to be specifically mentioned. It is not like against a vague person that sexual harassment has happened with me, not mentioning the name of the person who has done that. This complaint should not be entertainable. So properly the name of the person against whom the allegation is being imposed has to be mentioned, and the witnesses. If anybody, you have seen that anybody has witnessed that incident, then you can mention the name of the witnesses also, that these people were also present there when this incident has happened. So all the particulars has to be mentioned in writing in the complaint. And what is the time limit? If law is giving you any right, then that law is giving you right for a particular period only. It is not exercisable at any time. So it has to be filed within 3 months. If there are many incidents of sexual harassment happened with the woman, from the last incident within 3 months, she can file a complaint. And if she is mentally disturbed, she is not having that situation due to any reason, in exceptional circumstances, which is having this satisfying reason, 3 months extension can be given for filing a complaint. So 3 plus 3, mostly 6 months. More than that, no extension can be given. Who can file a complaint? Now, aggrieved woman, definitely with whom who is victim with whom the wrong has been done, she can only file a complaint. But in such cases when the woman is mentally not capable of filing the complaint due to mental or physical incapacity or death or otherwise reason, then she can then her legal heirs can file a complaint, or such other person who has witnessed that incident can also file a complaint. Now we'll discuss before inquiry. When there is any complaint, the ICC will not directly inquire the complaint. If the woman is interested to compromise or sit at the sit with the respondent and resolve the issues before the ICC, then ICC has to first see the possibilities of conciliation. But it should be on a request of women only. ICC cannot force a woman to settle the complaint or to sit for the settlement. So this should be on a request of a complainant. The ICC should take steps to settle the matter between the parties by way of conciliation before commencing any inquiry proceeding. So it has to be done before inquiry, because there is no benefit if the complaint can be settled on a particular point or coming to a particular resolution, then there is no need of inquiry. So before going for the inquiry, this step has to be taken. However, the ICC should not suggest a compromise between the parties. Yes, we have discussed that ICC should not suggest to a woman that you should compromise. Let's try to compromise the issue. This should not be done by the ICC. Conciliation allowed should be without any monetary settlement. This is very important thing. If monetary settlement should have been allowed by the Act, then most of the false complaints, there are chances of filing the false complaints, that women will come, file the false complaint and then settle it for huge amount of money. So therefore, monetary settlement is not allowed under the Act. You can settle the issues like if the woman is reporting to such person who is alleged of committed a sexual harassment against us, then she can be transferred to other department, or that person can be stopped from taking her reporting. Such kind of arrangements can be made for settling the dispute, but not monetary settlement. Once the settlement is recorded and the copies of the same are provided to the parties, the ICC does not have to proceed with the inquiry. This is very important. If the settlement is done, the ICC need not proceed with the inquiry, and they can provide the settlement copy to the employer and both the parties, whatever the settlement is arrived at. Like we will discuss inquiry procedure now. Inquiry procedure is same as the any court procedure. Like first of all, if the complaint is received, we will send the notice to the respondent or the accused person. He will file reply. The same way, he will also file his defenses that he has not done that, or with whatever he has to state that whatever evidences he is having, whatever the witnesses were present there in his favor, he can mention all such details in her reply. And after that, the opportunity of being heard will be given to him and the women, both the parties, their witnesses, whatever they name in their complaint and their reply, they will be examined, their statements will be recorded, and after that, they will be given the right to say whatever they want to say. After that, the ICC members will come to the conclusion of the inquiry, that whether after using all the records, there is any kind of sexual harassment happened or not. So that is the normal principle of natural justice has to be followed in any inquiry, in any proceeding, that has to be followed in this inquiry also. The ICC is also entitled to give ex parte decision. This is very important. If we have issued a notice to the respondent, he is not appearing, then ex parte decision can also be given by the ICC. Ex parte inquiry report can also be filed by the ICC with a notice in writing 15 days in advance. Under the advance notice देने के बाद, we will provide the 15 days time to him that this will be the last opportunity. If he will not appear, then we will give our inquiry report on the basis of documents available and the complaint. So despite that, if he is not appearing, or the complainant, that can be vice versa also. If the complainant has filed the complaint and she is not appearing after that, despite giving notices once, twice or thrice, then 15 days notice we can give, and we can, whatever the parties available, whatever the witnesses and documents available, on the basis of that, we can give the inquiry report. Without sufficient cause for 3 consecutive hearings, if the party, whatever they are not appearing, then in such cases, ex parte report can also be given. Such inquiry must be completed within 90 days. This is very important. always there is a time frame decided by the law for any particular act. So for this inquiry, conducting inquiry proceedings and giving report, there are time period of 90 days for conducting the inquiry proceeding. And after that, there is a time period of 10 days for submission of ICC report. Within 10 days from the completion of 90 days, we have to submit ICC report. ICC can also recommend. We have discussed this fact that ICC is not having power to punish anybody to take any action. The board of directors will only take action on the recommendation of ICC. So ICC, if found that any person is guilty of any sexual harassment, then they can also recommend reduction from the salary of the respondent, any amount as may be necessary to pay to the complainant by way of compensation. So that compensation amount can also be deducted from the salary of the respondent or any person who is guilty of committing a sexual harassment. Such action by the employer must be taken within 60 days of receipt of the recommendation by the ICC. ICC will not take any action, but after the recommendation, submission of inquiry report, the employer has to take action within 60 days from the date of ICC report. Now we'll discuss two major things about the inquiry. Full and final inquiry. The ICC report should be full and final, which should specify whether the incident of sexual harassment happened or not happened. It should not be like a vague kind of a thing and in between. It should be full and final and specifying that it has happened or not. Remedy during pendency. What is the remedies available to the women or a man? Because when the complaint of sexual harassment is being filed, during that period of 90 days, which is provided for completion of inquiry, during that period, what happens? The woman gets uncomfortable as well as the man gets uncomfortable working with the same woman. And that can deteriorate the situation amongst them. Due to that, the work can be affected. So in such situation, if the woman is coming to the approaching the ICC for any kind of measures, then in such cases, ICC can evaluate that what is the preventive steps needs to be taken for the welfare of both the parties. So potential harassment threats should be identified by the ICC. Whatever threats are available, that has to be identified by the ICC at the beginning itself to suggest preventive measures to the employer. That what preventive measures he can take to provide a safeguard environment to the both complainant and the respondent. The ICC on the written request of the complainant can direct the organization to restrain the respondent from reporting or reviewing the complainant's performance or writing any confidential report pertaining to her. Because that person against whom she has filed a complaint, if he will write and review her performance, then definitely that will be the biased one. And that will be having the impact of that complaint. So therefore, ICC can stop that person from reviewing her report or writing her report, confidential report. The ICC can also recommend the employer to transfer the complainant to another workplace, grant her leave up to 3 months or any other such relief as required. If she has been granted work from home for 3 months during the inquiry period or the 3 months leave, that leave will be in addition to maternity leave and other leaves under the other laws available to a women. So this can be the step taken by the ICC. The report of such action during the pendency of inquiry must be sent to the ICC. Any action taken by the ICC or the employer has to be intimated to the ICC during that period. The report of such action during the pendency of the inquiry must be sent to the ICC. If employer has taken any such action, the ICC should be informed about it. Now, this is a very important aspect, confidentiality. If in the big organizations also, most of the time, if there is any kind of sexual harassment complaint, then everybody is specifically has to maintain the confidentiality. And within the organization also, anybody making a complaint or having a sexual harassment incident, they should directly approach to the presiding officer or any member of the committee. They should not disclose it with the colleagues or anybody. So this confidentiality is a core aspect of this law. So while discussing with the media or anybody outside, we should not mention this any proceeding of the ICC or any complaint related to that. We should not talk to anybody about that until unless during the law or like during the course of inquiry it is required. Otherwise, we should not discuss. it should not be published in any kind of newspaper, media, or anywhere. And this also comes outside the purview of the Right to Information Act 2005. Because in any case, if any information anybody is seeking, they can file a RTI. They can take that information. But in these cases, nobody can file a RTI. Nobody can seek information relating to any sexual harassment complaint. Nobody can. So this comes outside the scope of the Right to Information Act 2005 and must not be addressed to the press or media in any manner. Any kind of complaint, any kind of incident, whatever the inquiry proceedings are done, whatever the witness, whatever the proceedings are, it has not to be disclosed with media or press. And this only after the conclusion and after the inquiry and action taken against that person, only this can be mentioned to the media that there was a complaint and we have specifically resolved that and the woman has got the justice. That's it. No name of the woman, no name of the complainant, respondent, nothing has to be specifically mentioned. Punishment for malicious and false complaint. Most of the time when we are there in any session, man's specific question from them that if there is a false complaint filed against us, then what is the remedy? So there is a remedy. Now courts are concerning about that also, that if any false complaint is being filed, then there is a strict action against that also. If an employee is found to have raised a malicious or false complaint or given any false evidence, such complaint or such person making evidence may also be subject to appropriate disciplinary action, which may include termination of employment, de-engagement of relationship with the company, or as the case may be. They can be terminated if they have, it is like in the inquiry, everything has to be checked. So there are witnesses, there are documents, evidences, and everything. Then if in inquiry it comes out that there is a false complaint which is filed out of any grudges, out of any anger against any man, then in that case, any person who has given evidence in that, any person who has filed such false complaint, they can be terminated or any other disciplinary action can be taken against them. Now, pertaining to this, we'll discuss together with this topic, we'll discuss this case law. Anita Suresh versus Union of India and others. In this particular case, the Honorable High Court of Delhi itself has found the writ petition without any merits and dismissed the petition with cost of rupees 50,000. The woman has filed this writ unsatisfied with the ICC report. So she has filed this writ. The court has found that the complaint is false. There is no merits in her writ, and they have imposed 50,000 cost on a woman to be paid by the petitioner. Petitioner was Anita Suresh, she is the woman. And also found that an appropriate action may be initiated against petitioner for filing false complaint of sexual harassment. There are other actions can be taken by the man also. If it is turned out that the complaint is false, sexual harassment complaint was false, then he can file the defamation case and other damages against a woman, subject to along with the cost imposed by the court also. So court has also suggested that appropriate action can be initiated against the petitioner for filing false complaint of sexual harassment. So the courts as well as the committee and everybody are very, very strict about these things, that if any false complaint will be there, action will be taken against women also. Submission of annual report. The last points the submission of annual report. Annual report, we have discussed that this is also a duty of ICC or committees to file a timely annual report. The annual report has to be filed in every calendar year, at the end of every calendar year. So what the annual report should consist of? Number of cases filed, if any, their disposal under this act. If any complaints are received during the entire calendar year, we have to mention those complaints, that how many complaints we have received and within how much time period we have disposed of that complaints and conducted the inquiry. That also has to be disposed or mentioned there. It is the duty of ICC of the organization to file a timely annual report to the district officer, to whom we will file this district officer, district collector office in the concerned area where our organization is situated. We have to file this report to that district officer. Now this is, we cannot say like this that we will not file the annual report, then nothing is going to happen. The district officer is monitoring the timely report is being filed or not, and they are also taking action. They are also sending notices now. So this is very important to file timely report. Penalties. if we have not complied the provisions of this act, there can be a penalty of up to 50,000. And if there is a subsequent contravention in complying with the provisions of the law or constituting an internal complaint committee, then in that case, the fine can be double the 50,000. Now say no to sexual harassment. Let us all contribute towards making our workplaces safer and happier. So the entire crux of this session was we should abstain ourselves from doing any behavior of sexual harassment. Being an employer, if we are employers, then we should provide safe working environment, what measures we should take. And if we are professionals, then to our client companies, what are the compliances we need to do, we have understood by this session. So what is the all, how you all felt after the session, and what is the consequences of sexual harassment we all have seen in this. So any questions, any queries regarding that, we will take up 5-10 minutes. We can take that. Yes, everybody can switch on their video if they can. We can have a discussion on that if anybody is having particular queries about that.
Thank you,
This
Juhi.
is very
A good session.
thank
Thanks.
you so much, sir. Thank you so much. We being professional.
Share the PPT after the session. You can share the
Sorry?
presentation.
Yes.
What I'm saying, after the session, you can share the PPT. Just tell Nitya to share the PPT.
Yes, PPT also we can share, and this session will also be there in our YouTube channel. So
Okay,
there
and,
also.
Just I remember there was something on POSCO also you people did. I don't know whether it was done online or whether it was like a formal session in that CP. POSCO, yeah. So is that something?
POSCO. There is a session on that. Yes.
No, you had already conducted one in CP.
Yes.
I remember a year back
Yes.
or something like that. So if that's available, that also maybe you can put. Or are you planning to do that online?
Actually, if it relates to a particular company or that, we cannot share that with the other
It was
people.
open house. What was done by Nitya, I think a couple of months back.
Okay. For on Posh, I think this is the second session I'm taking, and it is on the same topic which is I'm taking, because that time
POSCO.
Yeah.
Child...
POXO. Yes. That I'll see. That if that the PPT is available, I'll ask him to.
Right. Thanks, Akanksha.
Okay. So this entire session will also be there on our YouTube channel. If anybody is having any doubt or they want to go for it, because they can go there and see the link. We will get the link also shared in the group. You all can directly go there and see the entire PPT will also, because most of the time if we are having PPT, it is not understandable to go through that PPT properly. So discussion and the entire session also you can go and watch in the YouTube. So we'll share that. Anybody, any other questions? So either I have made everything clear or nobody is having questions. I ask for switching on the video if anybody can. Yes. Pooja, your voice is not audible. Unmute your mic.
Hello, ma'am.
Hello.
I have a question that can a single act cover under the sexual harassment?
Can a single act?
Single act cover under a sexual harassment?
Yes. Any single act, it is not required that it has to be subsequently again and again. No woman should wait. If any single act is also there, you should not wait to happen it again. You can file a complaint on a single act also.
Ma'am, in section 2A1 may agreed woman, in definition of agreed woman, there are mentioned that a second. Ma'am, in the definition of agreed woman means a relation to a workplace, a woman of any age, whether employed or not, who alleged to have been subjected to any act of sexual harassment by a respondent. The word here mentioned is has been subjected. What the means of this word?
has been subjected to definitely when she is filing a complaint. In our past, this has happened with us, na? That is why has been used in the form of past. Like
this is for
that. Yeah, it has happened with her. ये हो चुका है उसके साथ. Has been is used in that sense that ये हो चुका है any incident. That is why when the incident has happened with her, then only she will have the right. Then only she will have the right to file a complaint. So that is why has been is used. It is not mentioned that series of incidents should be there. Women will not wait if one incident has happened with you, somebody has touched you wrongly, you will not wait for doing that again. Definitely. So one incident is also reportable. And that is what we have discussed. If any incident at the first incident happens with you, you should report at that moment only. Otherwise, he will do the same thing with other women also. So why not you stop them?
Okay, this is for complaint person. Okay.
Yes.
Thanks.
Any other queries?
No, ma'am. Thank you.
Okay. So you all can, if anybody is having any query, they can let me know here or they can write it to me. I have shown my details there. The email ID and everything was there in the poster of today's session. They can write to me. I'll respond to that definitely. Thank you, everyone.
Thank you to all of you, to learned friends, to join here. And Miss Pooja, you can also drop your email ID and telephone number so that we all can connect it. And I would also like to say that yes, we each and second and fourth Saturday we have the session, this knowledgeable sessions, and our learned friends have a session. So whoever wants to join, you all are the most welcome. And so that you can drop your mobile number and email ID so that you can also share our certificates to the learned members join here. And probably some of the few members are joined new. So this is the only announcement that second and fourth every Saturday, second and fourth Saturday in every month, we have a session. And it maybe the topic, maybe the different topics, but all it relates to the legal fields. So all are the most welcomes. And Ms. Shreyas will give the vote of thanks to all of the learned friends. Thank you.
Thank you, sir. Am I audible?
Yes, you are.
Thank you. I would like to express my gratitude for enlightening session we just have experienced. It is evident that we have gained invaluable insight into the topic of sexual harassment in workplace. I extend my grateful thanks to the Vidya Vijay Foundation for organizing this educational session. Additionally, I wish to convey my appreciation to Mrs. Juhi ma'am for dedicating her time to serve as today's esteemed resource person. Her presentation was truly enlightening and comprehensive. During her session, ma'am has explained the multifaceted aspects of sexual harassment at workplace. She covered an array of crucial topics, including the significance of training and this contest, the legal frameworks governing sexual harassment, the constitutional validity of the relevant laws, various forms of sexual harassments, and she also recommended course of action for the victim and the responsibility of employer, the procedure of lodging FIRs, complaint, and many more things regarding sexual harassment in workplace. Thank you so much, ma'am, for such a knowledgeable session. And I would like to extend my sincerest gratitude to Nityanand sir for his support and leadership in making this session possible. I'm also deeply appreciative of the active participants of all the attendees whose thoughtfully question of presence contributed to the overall success of this informative session. Once again, thank you to all your invaluable contribution to this session. Thank you so much.
Thank you.
Thank you to all of our valuable 1 hour time. Thanks to all of you. Namaskar. Now you can leave.